Good morning, good afternoon, good evening to you all. Welcome, everyone. It is great to have you all here at this 4IP Council's webinar on the economic impact of patent holdout. My name is Axel Frazzini, and I am the Managing Director of 4IP Council, and I will be your host today. As you may know, 4IP Council is a not-for-profit organization based in Brussels, and we are focused on the link between IP and innovation. Our mission is to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, experts, IP organizations, and other stakeholders. On our website, we provide plenty of free material. For example, studies, guideline summaries of relevant papers and recordings of all the webinars. Like this one today. We also produce easy to digest content, especially tailored for non-IP experts, SMEs, and startups. Our aim is to assist innovative startups and SMEs in learning how to use IP to grow their businesses. If after today's webinar, you are interested in exploring the topic of patent holdout, you can find more information in other research papers available on the topic on our website. As you know, the Internet of Things is playing and will play a huge role in our societies and economies. Our big pillar of the IoT are standards, which are often protected by patents. To help you better understand what should be your behavior as a licensor and licensees of these patents in a good faith licensing negotiation, we have created a case law area on our website with summaries of court cases. You can now follow us on Twitter, LinkedIn, YouTube, and Instagram. Our handle is 4IP Council on all those services. That's a great way to find out about IP news, resources, interviews, and future webinars. We have also created a new podcast series that you may like to explore. Without further delay, it is my pleasure to introduce our panelists for today's webinar. Dr. Bowman Heiden and Dr. Justus Baron. Just a quick bio. The bios are just to show you how serious those researchers are. Dr. Bowman Heiden is currently the director of the Center for Intellectual Property, which is a joint center for knowledge-based business development between University of Gothenburg, Chalmers University of Technology, and the Norwegian University for Science and Technology. He is also the executive director of the Tusher Center for the Management of Intellectual Capital at UC Berkeley and co-chair of the Technology Innovation and Intellectual Property Program at the Classical Liberal Institute at the NYU School of Law. Dr. Heiden was recently a member of the European Commission high-level expert group on standard essential patents. Dr. Justus Baron is a senior research director at the Center on Law, Business, and Economic at Northwestern University's Priester School of Law. His area of expertise is the empirical economic analysis of technological innovation and markets for technologies. His main research interests are technology standards, patents, and licensing schemes. A final remark for the audience. Please do not hesitate to use the Q&A tool to submit your live questions during the presentation. We will take all the questions submitted in 30 minutes at the end of the presentation. You can find this Q&A tool in the lower part of the screen, so you can raise your questions anytime. Please don't be shy. Justus, the floor is yours.
Thank you very much. Thank you very much, Axel. Thank you very much to the 4IP Council for hosting us today, for giving us the opportunity to present our paper on the economic impact of patent holdout. So this is a working paper that Bo and I have written together, and we are very happy to present it today. It is mostly an empirical paper. It's a paper about measuring indications of impact of patent holdout in the economy. But nonetheless, we think it's important to start with a little bit of theory, a little bit of definition. So what do we talk about what do we consider as patent holdout for the purpose of our analysis? So as a preliminary remark, patent holdout is a transactional phenomenon. Patent holdout is a business conduct that arises in the relationship between the user of a patented technology and the owner of that patent in a situation in which that patent owner is willing to license these patents. And specifically, patent holdout is a peculiar form of infringement where basically it's willful infringement, and the holdout itself designates not the act of using the patented technology without permission, but it designates a conduct that perpetuates this unlicensed use basically by failing to enter into a license where such a license would be available on reasonable terms. And it is established by the infringer's unwillingness to license on such reasonable terms, where it's important to highlight that this does not require an absolute unwillingness to license. So it's not necessary that an implementer is totally unwilling to take any license for this to be a constituted holdout. At the same time, it's also not sufficient to establish that there's a willing licensor, that a patent owner is willing to extend any kind of license. So there is a frame of reference that is required in which both the willingness of the patent holder has to be established as reasonable, and the unwillingness of the implementer to take a license has to be established as unreasonable. So it's very important for us to make clear that patent holdout is related to norms of reasonableness, and these norms are context-specific, industry-dependent. So what is considered reasonable might very well depend and change from one context to the other. And very often it is one company's reasonableness is assessed by how that company's conduct compares to comparable peers. So if a company's conduct compares unfavorably with the conduct of similarly situated companies in the same industry. And this reasonableness has to be assessed both with respect to the terms at which the patent owner is willing to license, or the terms at which the patent implementer is unwilling to license, but it also has to be assessed with respect to the specific conduct that these different parties employ in view of concluding a license on mutually agreeable terms. So if a company, for example, is insisting on terms that are objectively unreasonable, then this would be clearly an incidence of holdout. But in other cases, it might be a combination of the unwillingness to accept certain terms with the specific means or conducts that the company pursues in order to obtain the more favorable terms that it seeks. So for example, if there's conduct that is specifically aimed at creating delay, or conduct that is specifically aimed at creating harm or costs for the other side without clear justification, without a clear relationship to the value of the license that is under negotiation, this could be also indication of holdout. But all this is to say that we operate a definition of holdout that is relative, that is basically industry specific and context dependent, but that is exclusively applied to situations in which an implementer had some kind of a reasonable expectation of being offered a license and then doesn't follow up on that with reasonable conduct that would allow that implementer to conclude a license on reasonable terms. And with that, I give the floor to Bo for further analysis of this.
All right. Thanks a lot, Justus. So building on the theory. So again, for everyone listening today, this paper, as Justus said, is empirical. We're trying to, I think for the first time, try to measure the impact of patent holdout, and for what we do to be correct in a way is based on this, on the theory of what we're looking at. also how we operationalize this theory and how we measure it, and we'll get into all three of those today. So that's why we're starting with the theory. And of course, another aspect of this is who are the people that are affected? Where would you be looking for people affected by patent holdout? And here we discuss in our paper three distinct contexts. One we call the hybrid operating companies. These would be companies that are both selling products but also willing to license. This would include companies that you see in the press nowadays, like Centripetal and Sonos and their lawsuits, but also most standard essential patent licensing among firms that produce products or components would fall into this category. We also have non-practicing entities. Those would be more R&D specialist firms where licensing is their business. And then, which could be under the category of NPEs, patent assertion entities. These companies also would be affected by patent holdout. And we're not making any type of judgment on business models. We're just saying that this would be the case in which people are trying to license, because holdout is a transactional phenomenon, as Justus said, and they could possibly be put in this position. So, and then of course, what would be the business response? What would you look for in these companies to see whether patent holdout was happening or not? Of course, so how people will respond to not receiving what they consider to be a fair royalty payment. Of course, they could litigate, and that's things that we can see. Still, when you look at litigation, as Justus said, the frame of reference, which we'll get back to often in this discussion, when somebody settles, I know in the recent case with Lenovo and Interdigital, the question is who won, who did better, what's the frame of reference, right? So again, litigation will provide information, but without a frame of reference, it's hard to understand which side received what they expected, or more or less than what they expected. It could be that they license or settle on inadequate terms. So even when people license, you would say, oh, well, this seems to have worked out, but not necessarily, because the terms of the license could be inadequate. People could be pressured to license. So you could have an underpayment, even though a transaction took place, and trying to understand that, of course, also requires a frame of reference. And the last one is that there could be no license at all. People could be in a situation where it's difficult to license, it's too expensive, the transaction costs or the politics are too great to enter into a license. And that, of course, would be a suboptimal outcome. And we'll get into that a bit more when we talk about this indemnification phenomena in a few minutes. All right, so what types of financial impact? So one last slide on theory, and then we'll get into the results. So we would want to look and see what would we see? What type of financial impact would we see? So when it comes to direct costs, we would see litigation and transaction costs. So people would be spending a lot of money trying to get licenses completed under reasonable terms, right? We would see reduced royalties, as we just discussed from the last, that people would enter into license agreements, but the royalties would be reduced. And this indemnification effect, which we mentioned, which would be where small companies that have patents don't have the financial resources to create a licensing program to enter into agreements beyond the costs of doing the activity. So they choose not to license at all. And then there's the case where the companies, where there's implementing firms that should pay a royalty, but their sales are low enough to, again, not be worth the trouble of patent holding firms to go and ask for a license. So you have both of these kind of no licensing zones, which we'll describe a bit further later on in the empirical section. When it comes to social costs, of course, you have problems across all different levels of inefficiency. So you can, as we discussed already, you can have these litigations and transaction costs that cause different inefficiencies in how resources are allocated. Maybe more importantly, as the dynamic inefficiencies that come because people are not compensated for innovative work. So then they spend less money on new R&D and new innovation. This is, of course, the whole reason for the patent system in the first place, is to solve the market failure with underinvestment in R&D. So if if people are not able to enforce their patents and get reasonable royalties, then they will again go back to underinvesting in the same way in the theory as if there wasn't a patent system. And of course, there's market distortions. If some people are paying, but other people aren't paying, this is going to have an effect on competitors in the market. And also the idea that if you can't get money through licensing, you can't have a division of innovative labor where you license to others and other people implement, then you'll be forced to use your patents in other ways or vertically integrate in less efficient ways. So all these things are impacts, both direct and social, that could be measured. One way that we describe this in a model, so there's a model in a picture, is if we go back again to this idea of a frame of reference. So there's this line that splits the graph here is the royalty, the expected royalties. I can use my pointer here. The expected royalties is this frame of reference. If we say that this is the reference in relation to patent licensing royalties and product exposure between licensees and licensors, the actual royalties would differentiate between these expected royalties based on the issues that we discussed. So the first is this indemnification effect. There is a gap here because of the product revenue exposure is so small that there's no reason to license. So you get the indemnification effect that creates an offset. That's the difference between the 45-degree line and the curve. So the difference between the expected revenue and the actual revenue curve is, of course, litigation and transaction costs that would cause a reduction in what the fair market value of the license should be. But then we have this idea of a threshold, and what this means is as the product revenue exposure gets greater, there's going to be a greater and greater incentive by implementers to hold out, because the amount of money on the line becomes higher and higher. So the curve, the convexity of this curve, the separation between the two lines and the point at which this indemnification effect occurs all depends on the nature of the context of the industry, as Justus said, but also on the nature of the patent regime in which these industries operate. So the weaker the patent regime, the more likely that there will be more distance between these curves, because it'll be more difficult to enforce your patents in general. All right, so moving on to the evidence then. So again, we've discussed the theory. Now we're going to operationalize a bit, and then we're going to add data, and we look forward to your comments on all three of these issues. So the first set of areas that we looked at was looking for systemic holdout in cellular standards. So we looked at the royalty gap in aggregate cellular SEP royalties, building on works from other people that have done research in related, but not specifically in this area in the past. We look at this, what we call the institutionalization of the royalty gap in aggregate royalty bases, where we question what should be the royalty base, where people sometimes argue the royalty base is too far downstream. We make an argument that it's maybe not downstream, is not downstream enough. And the last one, again, is measuring this indemnification effect, these actual missing SEP market segments that we discussed briefly that don't show up in the royalties because of the cost of the cost of doing licensing or litigating. And the second one that we look at is the evidence of systematic patent holdout in PAE studies. I'm not going to go into that much today. It's in the paper, and we'll put that out online shortly. But this is to look at the old literature that comes from the study of the economic cost of PAEs that was done by Besson and Moyer and colleagues, and to show how what they're actually measuring is not necessarily social cost, but actually holdout cost based on their market, their stock market methodology. So as we can go into this a bit more in the Q&A if you want, but the idea here is if you're going to measure if the value of intellectual property is based on how the stock market observes an enforcement, then that value is the actual value of the intellectual property, and therefore not necessarily the social cost. And if only a certain percentage of that is transferred then to the patent owner, then the difference then could be seen as the royalty gap or the holdout effect in that case. And the last area we look into is the evidence of systematic patent holdout from indicators of patent value. And so we look at it from 3 different perspectives, and we'll get into those briefly now. So the first one is the royalty gap in aggregate cellular royalties. So again, we need to come up with an equation to model this idea of expected versus actual royalties. So we say the gap is the difference between the two, similar to what we discussed and what was in the picture. And so how do we operationalize this more? So then we can't only look at what's received. We have to look at the expected aggregate royalty yield, but we also have to subtract away this cross-licensing effect, because the total licensing that is observed will be diminished by the fact that there's cross-licensing going on, and that shouldn't be included in the gap. So when we subtract the expected royalty yield that we get empirically from the actual royalty yield that we get empirically from an expected royalty yield, which we take based on different suggested aggregate royalties from the courts, and we subtract away the cross-licensing effect, we can come up with the royalty gap. So in our work, when we take the 2 studies, one done by Keith Mallinson and one by Galetovich, Haber, and Zaretsky, and we compare it with court determinations of what a potential aggregate royalty rate would be. Again, our reference for our frame of reference, our expectations. Then we have a small sensitivity analysis here that shows a potential patent royalty gap between $7 and $28 billion per year. When we talk about the institutionalization of the royalty gap, this comes from the idea that right now the royalty base is based on the mobile phone itself, but the mobile phone is really a bunch of markets in one. You have the phone itself, but you also have the access to the cellular connectivity from the operators, and then you also have all the apps on the phone. And to make it even more complicated, apps on the phone are free, and the money is actually made on another market for advertisement. Yet for companies like Apple and Google, this money is related into the total price or the total value created by a hammer. So when you look at the overall pie chart, you can see that the mobile services, the subscription that you get over the time that you own a phone for 2 years is worth over 50% of the total value or cost for the phone, whereas the sales of the mobile phone itself is only about 25%, and app services 5%. So you can see that if we were to rethink about the royalty base as a key ingredient in determining what should be the way in which reasonable royalties are determined, we would move from a royalty base in 2017 from $392 per phone to a total of $1,600 per year as a total revenue base for everything, all the value that's created on this stack of markets that you receive when you purchase and use a phone. And this amount was what, roughly 4 times as much or 5 times as much as the royalty base. So of course, this would obviously increase the amount of value that should be transferred if we kept the royalty rate the same. Now for the indemnification effect. So these are the missing market segments. So again, as I described, so if you have the licensees and the licensors, you have both small and large on both sides. When it comes to the vertical resource indemnification, this is the situation where licensees lack the resources to go after they don't have the resources in order to enforce their patents against other actors that are using their technology. And the revenue indemnification is when the implementer has too small of a revenue to make it worthwhile to go after a license. In other words, there's a bit of an implicit an implicit indemnification that that implementers receive, both by people not having the resources to do the licensing, or not having it worthwhile in relation to the amount of money that they could receive. And the rest is, of course, the negotiation in litigation space, and the size of this indemnification depends on the transaction costs and how much effort it takes to run a licensing business or to enforce your patents in a given patent regime. So using an example from 2015, this is the market share of mobile phone makers, and you can see the long tail. So if you calculate at a certain level of indemnification where the revenue from each of these small actors is too small in order to go after, this is also one of the issues that's raised now to SMEs, that certain actors are so small that it's not possible to, or not useful to license or interesting to license. This amount of money still adds up to quite a lot of value. So in 2015, even the sales of the long tail, which each individual actor would not be worth licensing, the total still added up to between 600 million and $1 billion per year. All right, now I'll hand it back over to Justus to talk about the indicators of patent value. Justus.
Yes. So this part is basically based on the idea that we have different types of potential infringement of patents, and holdout is just one peculiar type, one specific type of infringement, which arises in contexts in which there is a reasonable expectation of licensing. And we can observe certain patents that are often or even generally offered for licensing. So these patents, based on our definition, these patents are at outsized risk of holdout and holdout. So in particular, this is the case of patents that are subject to licensing commitments, where a patent owner has publicly committed that they are making licenses available to their patents on reasonable terms. But it's also the case for patents held by companies or entities that are not themselves practicing the technology, so that basically their only hope of generating revenue streams from the patent is through licensing. So one way of looking, maybe not at the actual total value of holdout in the economy, but at how it evolves over time, is just to compare how the value of these particular patents compares and evolves over time compared to other types of patents. And a sizable body of literature has done that exercise, in particular with a focus on declared standard essential patents. And they have found that these patents are significantly more likely to be cited, more likely to be asserted in court, more likely to be renewed than other patents. All these have been interpreted as indications that these patents are maybe of higher quality, but in particular are of higher financial value to their owners as compared to other patents. Well, what we have done now is to have a look at how these indicators have evolved over time, and in particular over the last 15 years. And what we can see is that in particular with respect to renewals, which are perhaps the most direct indication of how valuable these patents are to their owners, we can see that more than half of the advantage that declared standard essential patents have over other patents that are not declared standard essential patents has dissipated over time. So we can see that for renewal of US patents at 4, 8, and 12 years of age, we can see that the relative renewal rates of declared standard essential patents compared to other patents has quite significantly decreased, down from levels of near universal renewal of all declared standard essential patents 15 to 10 years ago. And one obvious concern or response to that is that, wait a minute, this is just based on declaration data. We know that a lot of this is fake. We know that a lot of this is basically populated with patents that are not actually essential. So maybe this is just variation in companies' incentives to disclose. So we have come up with a better, or what we think is a less problematic measure of potentially affected patents, where we look at patents that cite individual technical standard specifications as part of the prior art. So these are directly standard related patents. which are not necessarily standard essential patents, but we have found that the two populations correlate very significantly. And the population of patents citing the standard is less affected by variations in disclosure incentives. And we can observe the very same phenomenon that the relative renewal rates of the standard related patents compared to non-standard related patents has quite significantly declined over time, where most of that decline is actually coming from the last 5 to 6 years. So there is an accelerating decline in the relative value of standard related patents compared to other patents. And this is maybe related to specific idiosyncratic factors that affect standard related or standard essential patents. But we can see that it is something that is affecting standard patents offered for licensing more broadly. So one simple thing that we did is that we looked at the first assignee to which US patents were assigned, and using regular expressions, looking for patents that were first assigned to an academic institution, university or school or a public research institute. And what we find is that the relative renewal rates of these patents first assigned to research institutes has significantly declined compared to other patents over the same period of 15 years as what we have observed with respect to these standard related patents. And there's relatively limited overlap between these two populations. So these are really two distinct populations which exhibit a fairly pronounced decline in relative value compared to other populations of patents over pretty much the same period of 15 years. So this we think is an indication that what is driving this relative decline in financial value of these patents compared to other patents is specifically related to that attribute of these patents, is that they derive that the patent owners rely on licensing these patents to generate financial revenue. So what we think is going on here is that the environment in which companies try to license has become more difficult, which could be an indication that it has become more challenging to seek these expected or reasonable rates, or that what is considered reasonable rates has shifted over time in the last 15 years as a response to changes in the patent regime, but more broadly as a response to the systematic conduct in the industry by the companies that are using and that are supposed to license these technologies. So with this, we've concluded the measurement part, and we can now proceed to receive and answer your questions. And thank you very much for your attention already.
Thank you very much for your presentation. Not being an economist, I have to say that it is very clear, and I like the graphics. Everything based on empirical data is very useful. So we have received a few questions. As a reminder, you can use the Q&A tool that is at the bottom of your screen. Submit all your questions that we will take from now on. And to get started, the first one is, why are the concepts of patent holdout prevalent in SEP licensing?
Justus?
Yeah, I can take that. I mean, it's as I said, it's holdout for us is related to this reasonable expectation of licensing. So if a company just goes out and starts using patented technology that a patent owner intended to keep for its own exclusive use, we would call that patent holdout. That's just another form of willful infringement. So patent holdout is really about a company that would have access to using that patented technology on reasonable terms. It's just that the company's conduct is aimed at obtaining access on terms that are more favorable to the user than these reasonable terms. So this is basically our definition of holdout. And standard essential patents are usually subject to this commitment that a company makes at the time of declaring the patent as potentially standard essential, where they say, like, to the extent that this patent is standard essential, I'm prepared to make licenses available to these patents on terms that are fair, reasonable, and non-discriminatory. So this is this is really a prime example of a context in which this arises, where companies actually are allowed and justified to begin using the technology prior to obtaining a license to this, but then on the expectation that then they resolve this situation by working proactively towards a license, and where obviously a company that delays that engages in conduct that is aimed at avoiding that can potentially seek more favorable access at the cost of reducing the remuneration that the owner of the standard essential patents can get. So this is distinct from other industries in which patent protection is very important, where one of the primary channels of generating revenue from the patent is protecting the patent owner's own use of the technology and preserving a competitive advantage in the product market, restricting who can use the technology, where this particular conduct holdout plays no role.
Yes, I could just add that, because knowledge or technology is non-rival, any type of patent usage or technology usage can occur without the control of the person who owns it. It's just in SEPs, it's more part of the bargain through the FRAND license agreement that this is going to take place, and then negotiations are going to come later. So it institutionalizes this difficult market situation where someone is using something before they've paid for it, and you're arguing after the fact.
Okay, very good. We just received one of the new questions in the Q&A. Did your paper only look into cellular or also into other areas?
Into what? Say again, sorry.
Or other areas. Is it focused only on cellular connectivity, or you also have looked at other domains?
So I can say that for the part on the value, on the renewal data, that's not limited to cellular. That's based on any type of patents declared as potentially standard essential. But I mean, the declaration data is obviously very much skewed towards cellular, because we know that there's such this outsized share of ETSI 3GPP among the declared standard essential patents. But that's much true for our population of standard related patents, where patents related to 3GPP ETSI standards, it's just about 1/3 of the population. So this is more broadly patents related to technology standards in the ICT space.
And there also was a section where we looked at the past literature on PAEs and how that was defined, and that was broader. That was all types of patents where actors were actively trying to license, not just cellular.
Okay, very good. Thank you. Next one is, why is patent holdout difficult to measure in a specific transactional context?
Yeah, I can start with that. I think it goes back to the theory, and that's why I thought it was good to start with the theory as this frame of reference. It's always difficult if someone says, when someone says you're paying too much, the other person says too much compared to what? And if the other one says you're paying too little compared to what? So both hold up and hold out are deciding that people have paid too little or too much, but you need a frame of reference to understand that. And as we discussed, even with the transaction that occurs, it still could be too little or too much depending on other circumstances. So this idea of having an absolute understanding of hold up and hold out required us to look broadly at the situation as opposed to specific transactions, and to look at it from a much bigger perspective, and also to see this as something that is fundamentally difficult to understand until there's a lot of information brought out through, typically through litigation, to see how people are actually behaving. It's hard to see just from external public information. Justus?
I think there are different, if you think about how would I actually go about measuring holdout, I mean, there are different approaches that you can take. I mean, one approach that exists in the literature, there's a paper out there in an academic journal that says, okay, I have this very specific theory of holdout, and then I check whether behavior I can measure comports to that very specific theory. And if I find that this very specific theory doesn't seem to be met by the data, then I consider that the phenomenon holdout itself doesn't exist. And then another is to say, okay, I just compare the total value that based on some kind of absolute metric I think would be fair. And then if what is actually paid in the industry falls short of that hypothetical absolute measure of fairness, then I call that holdout. I mean, so we try to be somewhere in the middle where we basically say, okay, we take this gap as an indication of holdout. But we think that holdout is based on a specific behavior that is driving that. But our definition of holdout is clearly, as we said, it's relative. So like it's if everybody is doing it, then it's not clear that it's still holdout. So like that's true with respect to the rates. So if everybody is paying 1%, even if based on some kind of absolute metric, you think that 10% is a fair price, but then you're right to insist that you also should pay 1%. You're not holding out if you insist on being offered a license on 1% if everybody else is paying 1%. So it's basically whether you're holding out or not depends on what everybody else is doing. So it's really difficult to say in the aggregate how much holdout is there in the industry if the definition of holdout itself is based on what the entire industry is doing. So it's kind of very difficult to provide a social value, a social measurement of holdout, because the definition of holdout is based on industry standards. So that makes it very difficult and very challenging. That's why we have this kind of exercise where we look at different indications, changes over time, where we look at how it compares to what people have publicly said is reasonable, where we have indications of, okay, like it's maybe we are already excluding significant chunks of value by the way we go about measuring the value of these licenses, but none of that is directly a specific empirical measurement of holdout. It's basically, these are empirical indications or traces of holdout that is different from a direct measure, obviously.
And I think that's the good thing about the paper. So we try to say what we think holdout is. We try to say who's affected, how you would measure it in some way, and then we try to operationalize it, and then we try to use data to measure it. So we try to make our methodology completely open. People can question those different pieces, but now we're at least having a discussion about how you might actually measure it.
Okay, now looking at litigation, does patent holdout produce more or less litigation?
Yeah, so that's a good question. This goes back to the thinking that we just discussed a bit. So what would you expect if you thought that you couldn't get enough money for your patents because the patent system is too weak and it's too expensive, that holdout is institutionalized or systemic, would you give up? Some people would, right? So you might find it that some people give up. Other people would, the other way around would be that, well, the only way I can get my money is to litigate. So it depends on the resources and the situation. So if you tried to measure, you would probably find that you would find instances of holdout with people not litigating and instances of holdout with people litigating. That's why it's tricky to measure.
Yeah,
okay,
I think that the number of litigations has been used to measure holdup to the same extent as it has been used to measure holdout. And people have counted the number of times people complain about holdout as an indication of how much holdout there is, or the number of times people complain about holdup as an indication of how much holdup there is. I think that this is just not viable. I think that the number of litigations we see is an indication of how profitable it is to litigate, which is basically a calculus of how easy and how well companies can sustain their preferred position in court as compared to other venues. And that's pretty much it. So it doesn't really show you to what extent companies' positions in the market, in the negotiations, are reasonable compared to any kind of absolute benchmark of reasonableness. And if you shift the cursor by making a certain conduct clearly unacceptable, then behavior will shift, and because of this shift in behavior, incentives to litigate will respond to that. So maybe we get 400 lawsuits per year now based on current behavior, and then we shift the standards of behavior in the industry, and then we will see 400 different lawsuits per year, but it's based on very different conduct. It's just that I think it's fundamentally misguided to think that, okay, the amount of litigation we have is an indication of how reasonable people are in the industry. I think it's just not possible to do that.
Okay, yeah, I suppose the smaller companies don't have the resources anyway to litigate when they are victims of holdout. So, and now I believe the question is more: do you think, or maybe you found out during your research, that holdout will be or is bigger in the case the royalty burden will be shared across the value chain? So should the royalty burden be shared across the value chain? Do you think that will be more or less holdout? Or you have no idea?
I could, you want to go, Justus? I could take a stab.
No, go ahead.
All right. I think it relates a little bit to the second study that I showed, where you look at the royalty base, right? And you find that more of the value that people derive from a mobile phone occurs after the sale of the phone. So if you believe that in this case, the cellular standard is something that creates value for society, and you wanted to try to find a way to the easiest way to pass on this cost to the consumer for the benefit that they get, right? You would probably not want to pick a place in the value chain where those people would find that the amount of money you're asking for to share across the whole value chain is a lot of money in relation to what they spend or are very entrenched in their way. So you could make an argument, if we did this all over again, just to be provocative, that maybe it's better that licensing should take place at the operator level. I'm sure that'll provoke some people. But it's close to the customer. It's easy to pass on to the customer. It'll be a smaller amount.
I think it's also,
yeah, go ahead, Justus.
You can also look at the graph with the indemnification effect, where basically spreading it over many different actors in the value chain would make the per unit value of the licenses smaller. So based on our theory, there's kind of this sweet spot in the middle where like it's the actual royalties converge closest to the expected royalties, whereas like it's if one actor in the value chain has to pay the entire burden, let's say that sums up to 50% of whatever margin they have, because like the chip maker has to take on the entire burden for the entire industry. But so then obviously that creates a lot of resistance in that particular transaction, and then you get this type of discrepancy between what's actually being paid and what should be paid, because it's just a large amount of money that they're fighting for. So they're putting in a lot of resources to get away with paying less. But if, on the other hand, everybody is paying just like a 0 point something percentage of whatever it is that they're making, then obviously you will have a lot of small transactions in that industry where it's not worth fighting for, and you get a lot of indemnification of that particular time. So I think that based on that argument, it's good to find the sweet spot where it's you have one level in the licensing, in the value chain, where it's the per unit value of the license is big enough so that the patent owners care about trying to get the license, but it's not as outsized compared to the margin of the companies operating at that level, so that the incentives to hold out become disproportionate.
That's definitely one reason why upstream can be a problem, because if you didn't have everybody that was competing licensing, they would be at a huge disadvantage during that time. So you have this collective action problem. Good question.
Okay. Now we have a very precise question in the current context. I can understand. So the question is: hold up and hold out, both are related to uncertainty and disagreement. over fair and reasonable royalty rates. Do we need a government agency to set rates in order to discourage holdup and holdout?
You've been thinking about this a bit, Justus. What do you say?
I think that it's in a way, yes, in a way that having like it's a government say this is a price, and then basically that eliminates this ambiguity, right? And then you have, okay, then we have an absolute rate that everybody has to pay, and we don't have a margin of disagreement about that. But I mean, that's kind of destroying the market at the same time. So I think that what we're relying on here is the negotiation as the marketplace in which what is reasonable is being defined. And so I think we rely on reasonable conduct in these negotiations so that we have a market in which informative prices are being set. So this is why I think it's so important that we preserve some kind of absolute standards of reasonable conduct. It's because we require a functioning market, which basically is based on well-functioning bilateral negotiations. So I think that, yeah, I mean, you would get probably you would eliminate a lot of opportunities for holdout, but at the price of destroying a market mechanism for determining the prices. So I think I would reverse the argument by basically saying, okay, we patent holdup and holdout put the market at risk. And if we want to preserve the market as the instrument for determining prices for SCP license or for patent license more generally, then we need to preserve incentives to engage in licensing negotiations without holdout or holdup.
Yeah, no, I think that was well said. It's you can reduce uncertainty. I guess that's a specific answer to the question, but at what cost, right? That's always the thing. So, yeah. And I think that the market in this complex area will do better. And there's not evidence, as I think Justus' investigation showed, that the market is functioning well enough not to necessarily need anything drastic.
Yeah.
Okay, so
stipulating royalty-free licensing would take away a lot of uncertainty in a way, you know, like it's basically saying like it's exactly. everybody gets everything for free. I mean, then like it's we probably got rid of a lot of uncertainty.
Yeah. At least for some people, for a very short period of time.
Okay, one question is regarding according to your definition, what you have explained during the presentation. It seems that an individual company is holding out if it is unwilling to engage in licensing on terms generally accepted in their industry. Okay, but what if an entire industry is actually holding out? Will it be possible? What would be the consequences?
Yeah, I think that it's a definition problem. I think it's possible, and I think it's necessary to define holdout in a way that allows for generalized holdout. It's not because a purely relative definition of holdout, where it's purely, okay, you are the bad guy compared to everybody else, then like it's, yeah, you allow for declining standards basically, where at the end of the day, everybody gets away because everybody else is doing it too. So like I think that there needs to be some kind of objective anchor for what is considered reasonable conduct. So it's not enough to say, okay, you didn't do worse than everybody else, so you didn't hold out. I think that in addition to these industry standards, industry norms, there needs to be objective elements of defining what is reasonable conduct, what can be reasonably expected of a company in that position, in that situation, so that it stops perpetuating the unlicensed use. Even if everybody else is doing the same things, there are things that are unreasonable, even if everybody else is doing it too. So it's not a definition paper what we do here, so it's not a legal paper, so we don't try to come up completely comprehensively with the definition of holdout, where we say, okay, this is what objectively is required, even if it's not the standard in the industry. But I think you need something like that, otherwise it becomes meaningless.
And that's one of the things that we discussed, especially when this idea of what is the behavior? It's rational behavior, right? So what is it, bad faith or is it rational? And when do those lines cross each other? If a patent system was so weak that in a country no one ever enforced any patents, would it be bad faith to infringe, or would it just be rational? So again, actors in an industry will likely behave in a way that the system allows them to behave. And that's why we see this as a systemic issue to be resolved.
So actually what you just said is the patent holdup and patent holdout, is it individual or systemic phenomenon? Or maybe one of the two might be individual or systemic?
I mean, I would say it's both. So individuals will definitely make strategic decisions to do things, but as a group, the whole boats will be moved by the wave at the same time that individual boats will be doing their own things. Justus, what do you say?
Yeah, I mean, there's a literature in economics on declining standards. It's basically where you have like, it's if everybody makes these little deviations from what is considered socially acceptable, that translates into shifts in what is generally accepted behavior. And then like it's, if you have a little margin of tolerance for small deviations, then everybody deviates by a little bit. And then since we have shifted the guidepost, then everybody starts deviating from that again. And you get this race to the bottom where at the end of the day, everybody is behaving in ways that are objectively unrational or unjustifiable. So we have in patent licensing, especially in SEP licensing, we mostly rely on these comparatives, both in terms of what are reasonable rates, but also like what is reasonable conduct in the negotiation. Is it reasonable to wait 2 months before you answer or to a notice of infringement? Is it reasonable that you request claim charts for each patent in the portfolio? Is it reasonable that you insist on country by country licensing offers? These kind of things. All these questions are typically answered by what is considered normal in your particular industry context, and that's kind of has this property that what is considered holdout or what is considered hold up is fundamentally based on how your behavior compares to what everybody else is doing in your industry.
Okay, thank you. I think we are getting closer to the end, but the last question that we received is declared steps seem to have lost some value compared to other patents over recent years. Could that be because too many patents are actually being declared as potential steps?
Justus?
Sure, it's part of it, I think. I mean, it's the average value of declared SEPs obviously depends on the threshold of declaring a patent as potential SEP, and we have multiplied by 4 or by 5 the number of declared SEPs in these 15 years. So it's not necessarily shocking to see that the average value of individual patents in that population has decreased. But I think what's more telling is that this holds true in this broader population of standard related patents, not only in the declared standard essential patents, and that we see the simultaneity in the trend in the standard related patents with these patents first assigned to university. I think I wouldn't give too much weight to the finding if it was based on declared SEPs alone, but seeing that there is this parallel trends between patents assigned to universities, which clearly rely on licensing for making these patents profitable, and patents that are standard related, which based on French principles are available for license, makes me think that this is driven by, or this at least to quite a significant extent driven by deteriorating conditions in the markets for licenses.
Okay, very good. One statement that I received, this is not a question, they say, but not all the SEPs are equal. So we tend to take like the SEPs as a general term, however, some SEPs might be more essential than others.
Absolutely.
Will you agree with that?
Absolutely.
Okay, so this is
It's no
clearly
different,
a great
no
topic.
different than patents in general. So
Okay, thank you very much for your presentation, for all your answers, and also for providing so much clarity on this very complex topic. So now it is time to conclude, and I would like also to thank all the attendees for asking questions, for coming to this webinar. The recording will be made available in the next few hours or maybe a few days. So please check out the 4IP Council's website tomorrow. You have also the possibility to download the executive summary of this ongoing paper. Okay, on the website, you will find the podcast, the webinar recordings, all the latest research papers that we have published. And finally, please, you might receive a questionnaire, a 1-minute survey to provide your thoughts about this webinar. That would be highly appreciated if you can do it. So thank you very much and goodbye.
Thank you.
thank you.